The Corporate Transparency Act, whether you're ready for it or not, it's coming to a theater near you on January 1st.
And just like that, the show has begun. In fact, it's already been updated since my last video, where now you have actually 90 days to file your information with the government instead of the previous 30. Well, that's only until this year, because starting next year, you'll have to do 30 days from the time of filing. But in this video, I wanted to talk to you about the 3 best practices I've been advising all of my clients to take regarding the Corporate Transparency Act. So let's get to it. The first best practice is to make sure that you have a written policies and procedures in place to make sure that all of the members and managers are complying with these new requirements. You want to be able to address some of the questions that are going to pop up, like who is going to be responsible for gathering all that information and making the filing with FinCEN? Or how is all of that sensitive information going to be stored? Or what happens if one of the members or managers refuses to provide you with the information and therefore you cannot make a timely filing with FinCEN? Who is going to be in charge of communicating any changes that are required to be filed within 30 days? And finally, what are some of the penalties that you want to implement if one of the managers or members does not provide you with the information required or provides you with incorrect information, resulting in some kind of a penalty for you or the company? Remember, any one of the members or managers that doesn't comply can affect all of the other members and the company itself. The second best practice is to make sure that you get all of the beneficial ownership information to the preparer or the one that's filing the entity as soon as possible. Every single filer that I have talked to has already told me that they will not file any entity until they have all of the information required from all the members, managers, and beneficial owners. And the reason for this is because the filer, or the one that's actually making the filing with the Secretary of State, is also liable if they don't provide the proper information. So in order to protect that liability, filers such as my own company will not actually make any filings until they have all the information from all of the beneficial owners. So if you're starting a new business and there's time sensitive, make sure that all of that information is gathered quickly and provided to your preparer. The third best practice is to make sure that you update your operating agreement, especially if you have an entity prior to January 1st, 2024. You want to make sure you draft some sort of an addendum or an amendment to the operating agreement to make sure all of these provisions and policies and procedures that we've just talked about are included in the operating agreement, which will then bind all of the members and managers to comply with that. Otherwise, there's no legal requirement for the members to comply. So make sure you amend your operating agreements. And for any entities that you file moving forward, just make sure that your operating agreement already has provisions of the Corporate Transparency Act and the requirements that you want the members and managers to follow. And I'll throw in an extra bonus. Make sure that you're staying up to speed with the Corporate Transparency Act. There's been already a lot of changes in the regulations. And as you guys know, ignorance of the law is not an excuse. So you want to make sure you're paying attention to this so that if there are any changes, extensions, or even reductions, that you're aware of them and you can properly comply, because at the end of the day, it's going to be your obligation for the company and for yourself to make sure that these filings are made on time and are accurate. If you're not super familiar with the Corporate Transparency Act, here's my original video that I made about all of the things that need to be complied with this new rule that took effect January 1st, 2024.